Hello there. Thank you for joining me, and I hope this video finds you well. My name is Michael Toback, and I'm an attorney here at Siegfried Rivera. Part of my practice focus area is community association law. Within that area, there's one very common issue that seems to arise throughout all associations, whether we're dealing with large associations, small associations, condominiums, homeowners associations, whatever it may be, and that issue is nuisances. Therefore, today's short video topic will be providing a brief overview on the common issue of nuisances, some common nuisance examples that are encountered, how nuisances can and should be addressed within your respective communities. Now, generally speaking, community associations often face a range of common nuisances that can disrupt the harmony of a building or of a neighborhood. Associations frequently receive complaints regarding a slew of nuisance issues, some examples of which include pets, general noises such as loud music or weights dropping from the unit above during a workout, parking issues, and also smoking. So during this brief video, we explore effective tactics to assist community associations in navigating these challenging problems. Now, again, these are just some of the issues you may encounter within your communities. And honestly, I'd be surprised if you didn't think of some other examples that you can think of within your respective communities. But overall, the processes and tactics for addressing the alleged nuisances are generally similar, so keep them in mind. Okay, so let's start by talking about pets. Dealing with pet-related issues within community associations can undeniably be a very sensitive subject. Some owners and residents love and enjoy their pets and animals, while others prefer not to be around them and perhaps even share a deep-rooted fear in them. For starters, from both an association and member perspective, it is important to know your community's rules and regulations regarding pets. Is the community pet friendly? Does the community restrict the number, size, or breed of the pet? Are there promulgated rules regarding the pet being leashed or certain entrances and exits that it may use? For example, in a condominium high-rise building, do the rules and regulations prohibit pets from riding in the main passenger elevators? Do the rules and regulations address pickup and waste management of the pet? I would encourage both board members and member owners to review their governing documents and familiarize yourself with the language regarding pets. And from a board of directors perspective, if you believe the language in your governing documents may be a little weak or light, or do not provide enough guidance as it relates to pet management, we'd again encourage you to reach out to qualified legal counsel practicing in this area to help guide you in amending your documents and or promulgating new rules and regulations. Now, as it relates to pets, the common nuisance we hear and see include excessive barking and or lunging at residents and neighbors. This behavior can certainly constitute a nuisance as defined within your respective community's governing documents. Overall, open communication between residents and management about pet concerns foster understanding and collaboration. However, when appropriate, incident reports should be generated regarding the nuisance behavior, as proper documentation is important for all parties involved. Ultimately, while pets may be allowed within your community, even in communities that do not allow pets, but do make an accommodation for a request regarding an assistance animal, no animal may constitute a nuisance and interfere with the reasonable possession and enjoyment of one's property. Having said that, it is important for an association to know the difference between pets and assistance animals, and within the assistance animal category, with it between emotional support animals and service animals. These key distinctions impact how and where the animal can roam throughout the community, for example, irrespective of the association's rules and regulations. Ultimately, associations should seek guidance from their attorney on how best to handle assistance animal accommodation requests. Truthfully, we can do an entirely separate video, and perhaps will, on pets and assistance animals, but this was just touching on them within the context of nuisances. Therefore, let's move on to another example. Noises. Noise disturbances within community associations can lead to significant conflicts within a community. It is important to encourage residents to practice good neighborly behavior and respect each other's quiet enjoyment of their properties, as doing such can go a long way with all parties to enjoy peaceful possession of their units and or homes. Nevertheless, there are many noise disturbances that we do see arise in community associations. Some of these include loud weekend parties late into the night, either at a neighboring unit or perhaps in a neighboring residence. Others include units in a condominium building that are enjoying a home workout, but disturbing neighbors around them and below them by continually dropping the weights onto the floor. In fact, just one specific example I recently dealt with. An elderly woman in a condominium building was screeching her walker across the floor every time she would get up and move. This led to nuisance complaint issues with the neighbors below and around her. Like we discussed previously, it is important for both boards of directors and its members to have well-established rules and regulations regarding noise levels. Another example could be as simple as construction. It is common for associations, especially in South Florida, communities where there may be a clear season in place, where many are in towns or require certain timeframes to be quiet hours that prohibit construction and/or movers present during that time frame. Overall, a well-outlined set of promulgated rules and regulations addressing noise in communities can go a long way in curtailing disruptions. However, there inevitably will be situations and instances, perhaps in your respective communities, where a good set of rules is not sufficient on its own to deter noise disturbances. In those cases, associations and management, along with the disturbed neighboring owners, should continue to document these incidents via reports, and if necessary, especially in a specific and potentially hostile situation that could arise, to contact law enforcement as required. I can't tell you how many times I've either brought forth a case where a police report is something I really wish I had, or the police report made the difference in a case. Ultimately, neither neighbors nor the association itself can nor should be expected to handle specific nuisance issues as they arise in real time. Rather, those instances likely call for the police. Therefore, in those cases, we do recommend you get the police involved and allow them to make the appropriate determinations. While we hope involving your attorney's office and of course law enforcement never becomes necessary, as it relates to noise nuisances, if needed, such course of action should be taken. Let's move on to another nuisance example. Parking violations in community associations can cause a great deal of frustration to associations and its members, whether that be in a condominium setting where there may be limited parking spaces and/or not enough guest spaces, or in a homeowners association where there is limited driveway parking and street parking becomes a nuisance. Overall, like with the topics previously discussed, proper enforcement and the best way to avoid these issues start and often end with having a set of rules and regulations that specifically address the issue. Therefore, here, we'd like to see some strong parking restrictions throughout your governing documents. Community associations can employ strategies like assigning parking permits, guest parking rules, utilizing towing services for unauthorized vehicles to alleviate parking issues, or something as simple as, for example, in a community, determining which side of the street cars may be parked on during each month, as well as determine specific timeframes which guests or contractors can utilize parking spaces without being ticketed or towed. Parking issues, as you can imagine, are prevalent throughout communities. I've personally dealt with a number of parking enforcement actions whereby an owner, for example, continues to park their vehicles on the grass in violation of the governing documents, in turn constituting a nuisance. We'd encourage associations to be very clear with their membership about their parking rules and regulations and how they will and can be enforced. Likewise, we encourage owners to carefully review your community's rules and regulations to familiarize yourselves with such parking regulations so as to ensure compliance. As we've discussed, ultimately, it is important for associations and its members to have well-established rules and regulations regarding parking and to communicate with one another. Let's move on and address one more example. Smoking. Smoking both in units and on the common elements, inclusive of cigarettes, cigars, vaping, marijuana usage, or otherwise, are prevalent issues within communities, especially for this example, in the condominium setting where units lie in such close quarters. It is important for associations to balance the rights of smokers and non-smokers, which analysis, as you can guess, starts and often ends with a review of the association's governing documents. It is critical to know what your respective governing documents state as it relates to smoking, if it is prohibited, and if so, where is it prohibited? We'd encourage associations to get with their qualified legal counsel to discuss their governing documents as it relates to smoking and what actions can and should be taken in relation to same. Most declarations, for example, will include language regarding nuisances and improper uses, And if persistent complaints arise from smoking permeating between units, the association can attempt to utilize the nuisance provision outlined in the declaration in tandem with its promulgated rules and regulations. Ultimately, owners are entitled to quiet and reasonable enjoyment of their units, which likely includes their ability to enjoy their unit without smoke permeating throughout. One example as it relates not to cigarettes, but marijuana specifically, if residents are legally registered to use medical marijuana, the association can request a copy of their medical marijuana use card for record-keeping purposes. Ultimately, with smoking and all of their nuisance issues discussed previously, the issues themselves are very fact-based and incident-driven. What are the complaints that are coming in? Who is being affected? Are there reports that have been generated about these incidents? How often have they been occurring? Are they still occurring? Have violations notices gone out yet? Should they go out? These are all questions that associations should be ready to address to tackle nuisances. And it would be recommended that those conversations include not only your board of directors and your management company, but also your qualified legal counsel to assist you and guide you through the process and answer any questions you may have, including assisting you with not just the initial violation notice, but especially if legal action becomes necessary either in court, in a pre-suit mediation setting, or perhaps an arbitration with the Division of Condominiums. Ultimately, the goal, of course, is to get everyone in the community to live together in harmony and avoid any nuisance issues, but should they arise, to have a way to quickly resolve them. Nevertheless, should matters begin to escalate, it would behoove associations to ensure the nuisance is properly documented and addressed, and that your legal counsel is advised they can guide you along the way. Again, these were just a few of many examples we can think of with regard to nuisances. I'm sure you can think of others in your communities, and hopefully you can apply some of these practices and tactics that we've discussed. So I hope this short informational video was helpful. If you need our firm for any assistance with your community association needs, including nuisances, please do not hesitate to contact us. Thank you so much for joining me, and I hope you all take care.